This is not your average harassment case. This is the kind of courtroom moment that leaves jaws on the floor. Meet Mr. Fleischer, a man facing serious charges for a torrent of threatening messages, including chilling words like "kill yourself" and "your family hates you," but that's just the beginning. What starts with harassment quickly spirals into something darker: allegations of physical abuse over socks. Yes, you heard that right. As the judge digs deeper into his violent history and confronts him with a rap sheet longer than a CVS receipt, tensions explode. Stay locked in, because what happens next is the definition of courtroom fire.
About September 19, 2024, an officer conducted a follow-up in regards to an assault on a family case. Upon further investigation, the officer made contact with the complaining witness, who reported that the defendant had been harassing her since September 18, 2024, by sending her videos, voicemails, and text messages containing horrible remarks, approximately 50 to 60 messages in total.
Let's pause right there. Over 50 disturbing messages, voicemails, texts, explicit threats, all within 24 hours. That's not just a digital outburst, that's legal dynamite. In most jurisdictions, harassment like this is enough to trigger restraining orders or even felony charges if threats involve harm or suicide incitement. Legally speaking, those texts like "I want to watch you suffocate" cross into terroristic threat territory. And remember, every single message can serve as separate evidence, multiplying legal exposure. But here's a question for you. If someone sent you this level of digital hate, would you feel safe walking outside?
I see that he has also picked up a felony assault against his complaining witness as well.
Yes, sir.
Okay, what happened in that one? And I'm assuming it's the same date as this one, so I'm assuming it's out of the same transaction.
I'm not sure. So it says that I don't believe so. It says that on September 18th in Harris County, officers were dispatched to an assault. The complaining witness advised that the defendant came home upset about socks not being in the closet. The defendant punched the complaining witness with a closed fist on her foot twice, on her right thigh, and twice on her left thigh.
This just escalated fast. A violent reaction to socks not being in the drawer. That's not a domestic dispute, it's assault, and it's systematic. Multiple punches to the legs, bruises described in detail, and a 2-year history of abuse. That's enough for any DA to push for enhanced sentencing. The physical evidence alone, the green, purple, and red bruising, suggests this wasn't just a moment of anger, but a pattern of domination. The law doesn't just look at this incident, they'll weigh the full context. Would you consider this man a danger to others? Because the court certainly does.
This is Mr. Fritter. He hasn't harassed, Mr. Fritter, let me tell you something now. You scare me.
And that's the moment everything shifted, when a judge tells you, "You scare me." That isn't theatrical, it's a legal signal. Judges rarely express personal fear unless they're considering serious restrictions, no contact orders, emergency protection, or even revoking bond. Mr. Fretter's criminal history: DWI, trespass, assault, reads like a career criminal's greatest hits. And now add harassment and felony assault. This man isn't just towing the line, he's obliterating it. From a legal standpoint, the court must act to protect not just the victim, but the public. So the judge isn't playing around, she's laying the groundwork to shut this man down.
Would that be a no contact in this court, Judge?
I don't see that the rip has been.
Are you Miss Lisco?
Yes, sir.
That's Miss Lisco right there. Come up, ma'am. Come up. I'm sending you for a drug and alcohol test right now, Mr. Fritter. I want to protect you as much as I can. No one has to have this kind of treatment whatsoever for any reason. And I will do everything in my power to protect you. All I need you to do is tell me. All I need is, please give me the word. Mr. Fritter, look at me. You so much. I'm Can you imagine what life is like when someone has to walk on eggshells because they have the fear that if they make someone mad in the smallest respect of having Socks not in the damn drawer. They're liable to get a beating. Can you imagine what life is like to live with that kind of fear? You're going to live it with me now.
This speech right here, this is courtroom poetry with teeth. The judge goes nuclear, making it crystal clear. Mr. Frieder is on the thinnest ice imaginable. The phrase your head will spontaneously combust isn't just dramatic, it's a metaphor for the explosive consequences waiting if he so much as breathes wrong in legal terms. This is bond modification territory. Judges have wide discretion to increase bond amounts or revoke it altogether if they sense ongoing danger. But beyond legality, what's striking here is the emotional weight. This isn't just protection. It's a call for justice. Would you trust this man in the community?
I find that you treat anyone or put anyone in fear or put anyone in harm's way. So help me. I will grow horn and tails because I will be so upset. And it will be on you. Do you understand?
Yes.
Abel,
Yes, sir.
I'm going to keep Mr. Freder so close to me that it's just ridiculous.
Yes, sir.
I'm entering what's called a magistrate's order for emergency protection. This is a court order that identifies her as a protected individual. You're not to have any kind of communication whatsoever. You're not supposed to have you will not have any threatening or harassing contact. What is threatening or harassing doesn't matter what you think is threatening or harassing. It's what she perceives. So if I go like this, is that threatening or harassing? It most certainly is. And it's enough for me to put you in jail and make your bond $150,000, maybe 50, maybe 20. But I will do, Mr. Freder, I will do everything in my power to protect every single person of this county. And I don't care if you're kicking, screaming, crying because you go to jail and don't have anyone to bond you out.
Question. Your husband and wife of 10 years is kind of difficult situation that we live together.
I want to protect you, ma'am. And you know, the problem is that now that he's picked up these two cases, times will be just even more stressful. We have these protective orders. They're basically like cooling off motions so that, you know, you can separate, enough time will pass. People can kind of cool down, you know, so they're not under the stress of the excitement and then unleash on you. The last thing I want is for you to suffer any kind of harm whatsoever, you know, and I that's all I want. You know, all I'm asking is how things should be normal. Like, I'm not asking him for him to do Pythagorean's theorem here. So, I don't know. You know, what I'd like is if you please just talk to our DAs here. But I'd like you to have their phone number at the minimum so that should anything ever whatsoever, all you have to do is let us know. And then
I have been in contact with the DA, so should it not be assault?
I'm here for you. And I want to make sure that you're okay. You know, I've given him a lawyer. He knows what's expected of him. And I'm going to drug test him like crazy to make sure that he's not using alcohol or dope. In fact, I mean, I'm going to test him 2 times a week. I mean, I'm setting him now because I want to know what, if anything, is in his system. And then we'll go from there.
Judge, he will come back to positive, but that's prior use from.
What were you going to test positive for, Mr. Freder?
Marijuana
Okay.
and ketamine and probably some other stuff that could have been in the ketamine. But I mean, straight up, that's probably it.
Mr. Freder, I'm going to test you. These are your bond conditions that are going to apply to you now. And if you fail to live up to these bond conditions, I'm just going to let you know. That's it. You will appear to me here 2 times a week to take drug tests. And if I find anything is in your system, and I don't care what it is, I'm going to lock you up. You're ordered not to use any kind of dope or alcohol. And if you can't get this monkey off your back, because I am now giving you the opportunity to do it on your own. If you're incapable of doing it on your own, then I'm going to do it for you. Do you understand? No dope, no alcohol. And when I mean no alcohol, I mean no alcohol from any source. No isopropyl alcohol, cakes, candies, foods, gums, energy drinks, tequila lollipops, hair dye. I've heard it all, and I don't care.
Now this is one of the most comprehensive bond condition speeches we've ever heard. No alcohol at all, not even in mouthwash or food. That level of specificity shows the judge is dealing with someone who has likely played games with testing in the past, and here's the twist. He admits he'll likely test positive for ketamine. That's not your everyday recreational drug, that's a powerful anesthetic. The judge is clearly sending a message: comply now or face lockdown. The inclusion of anger management 3 times a week shows this isn't just punitive, it's corrective. But the real question is, can someone with this much baggage truly reform under supervision?
You now have the opportunity to address these things on your own. If you don't.
So what's the bottom line in the case of Mr. Frieder? We've got harassment, physical assault, threats, substance abuse, and a pattern of control that left his victim terrified over something as small as socks. The judge laid down an ironclad protection order, layered bond conditions, and a crystal clear warning: mess up again, and you're going straight to jail. This wasn't just a hearing, it was a reckoning. But what do you think? Should this man get a second chance, or is this a case for maximum punishment? Let us know in the comments below. And if you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns every week.